The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. We'll be starting we'll just leave it for another minute or two. Or just for the people that are joining us on webinar, just to let them know we'll be starting in a minute or two. There was an extra challenge that who works on the track? Is it Victrac? That the tramways have set. That made an additional challenge for everybody to come in this morning. So we'll just wait for another minute or two and we'll get started. Okay, so thank you all for coming. We acknowledge the traditional owners of the land on which we meet today and pay our respects to their elders, past, present and emerging, and the Aboriginal elders of other communities who may be with us today. Thank you for coming along and thank you for your commitment to getting to know more about Victoria's protected disclosure system and the changes that will start on the 1st of January next year. Joining us, we have a broad cross-section of the VPS here with us. We have a number of lawyers and a number of integrity professionals. So I hope we'll be able to get a good conversation going, especially towards the end, but we'll hopefully answer most of your burning questions about the changes. Joining me here today from IBAC will be Sophie Molyneux, who's a senior lawyer in my team. She'll be helping with the presentation itself. We're also joined by members of our assessment and review team. We've got Sky. I'll have to ask you to put your hand up. Sky. We've got Sian. We've got Jasmine. And we've got Sue Kaparalakos, who's the manager of assessment and review. So that's the team that you'll have the pleasure of dealing with, if you haven't already, in relation to notifications to IBAC. We'll be using Slido for questions. I don't know how many of you are familiar with that. Now this is, there we go. May have used Slido before. It's wonderful technology that enables questions to be asked from the floor and for those questions to be captured in the system. And you can say whether you like a question, and it automatically orders the most popular questions to the top. And so we'll be opening up the Slido deck towards the end of the presentation, and that will drive the questions and the conversation that will follow. So going through the presentation, if you have any questions, just pop them in Slido. Everybody that is looking at Slido will be able to see those questions and say and indicate a like for a question, and then they'll be ordered in that. They'll come up on the system in that order. So to access that, you go to slido.com and then you enter the event code. It's very simple. You just go to slido.com and then you enter that event code, PID. That will get you straight into the system. Okay, so what we'll be doing today is threefold. We'll be providing an overview of IBAC's role in the Victoria's integrity system. That'll set the context for an overview of the protected disclosure system as it operates now, before we then go into providing an overview of all the changes that will commence on the 1st of January, before we finish with some case examples and then go to questions after that. So, IBAC. IBAC is Victoria's first anti-corruption commission. We commenced full operations in February 2013. Our vision is to build a corruption-resistant Victoria. Our purpose is to prevent and expose public sector corruption and police misconduct. To do that, we execute the functions of investigating and exposing serious corrupt conduct and police misconduct, and our function of educating the public sector and the community about the impacts of corruption and misconduct, while we build public sector capacity to prevent corruption from occurring. We're independent of government and we're accountable to the people of Victoria through the Victorian Parliament. Our Commissioner is Robert Redlick, QC. He's an independent officer of the Victorian Parliament and he's responsible for the strategic leadership of IBAC. We have around 130 staff from a diverse range of backgrounds such as investigations, law, forensic accounting, information technology, education and administration. Victoria's integrity system, this slide just provides an overview of some of the bodies that constitute Victoria's integrity system. It exists to protect against unfair or dishonest conduct such as corruption. So everyone can expect the highest standards from our politicians, public servants, courts, local councils and police. The system is comprised of a number of agencies, each with a distinct role. Together, they form a network that have interconnected functions. These agencies aim to give Victorians confidence that public officers don't grant favours or privileges, that decisions are made honestly and in the public interest, and that government resources are distributed fairly. They also have an overarching shared responsibility for protecting integrity in the Victorian public sector. Along with IBAC, the other independent integrity agencies reporting directly to Parliament are the Victorian Ombudsman and the Auditor General. Other agencies have specific functions relevant to their specific jurisdictions. The Local Government Inspectorate and the Commissioners for Freedom of Information, Victorian Public Sector Commission, the Equal Opportunity and Human Rights Commission and the Judiciary. All of these bodies contribute to this complete network of integrity agencies. So our jurisdiction, IBAC's jurisdiction, extends across the whole of the Victorian public sector, which includes members of Parliament, the judiciary, police, state and local government. This adds up to around 300,000 Victorian public sector employees in around 3,500 separate organisations. What do we do? A key function established by our legislation, the IBAC Act, is to receive and assess complaints and notifications of suspected corrupt conduct or police misconduct. Complaints come from members of the public, usually made directly to us. Also, notifications, of course, come from public sector entities, including Victoria Police, state government agencies, local councils, under mandatory notification requirements. Our Act requires us to do one of three things with a complaint or notification. I'll talk more a bit about this later. We are required to either dismiss, refer or investigate a complaint. We can also conduct preliminary inquiries to help us determine which of those steps to take. In addition to the traditional complaints handling model, we've also built a strategic research and intelligence capacity, which also helps to inform our assessments of complaints, as well as our investigations and our prevention effort. We have powers that are similar to a Royal Commission. We can undertake search and seizure of evidence. We can apply for telecommunication interception warrants. We can subpoena documents. We can conduct private or public examinations, and we can prosecute. So, as mentioned, we've got a responsibility for exposing and preventing corrupt conduct across the whole of the Victorian public sector. Our investigations may use our special powers, and we undertake prevention effort to help prevent public sector corruption and police misconduct. So, in our first 5 years, just some numbers, we assessed just under 18,900 individual allegations of corruption. We completed 55 investigations, of which 5 involved public examinations. As a result of those investigations and other activities, we made 93 recommendations to police and public sector agencies. We undertook 383 reviews of matters referred to us by other agencies for investigation. We reviewed those matters to help determine if the matter was handled fairly and investigated thoroughly. In the first 5 years, we published 39 reports as part of our research and strategic intelligence work. Our most recent reports you'll find on our website, managing corruption risks associated with conflicts of interest, and a special report on corruption risks associated with procurement in local government as the most recent examples of our reports. In the protected disclosure space, out of those 18,869 allegations that we assessed, 1,756 were determined to be protected disclosures. Now I'll turn to a bit more about protected disclosure system. Of those in the last 12 months, this just shows a profile of where the subject matter of the complaints that we've received. This is very fresh data, relates to complaint cases that we've received from the 1st of October 2018 to 30 September this year. So 1,733 complaint cases, 61% of those related to complaints about Victoria Police, 10% Victorian local government, 30% of particular interest to this group related to the Victorian public sector. So that was 519 individual cases relating to allegations of improper conduct or corrupt conduct in the Victorian public sector. So, the public interest disclosure system. So the system is designed to give protections for information about persons in public bodies or public offices engaging in improper conduct or taking detrimental action. The purpose of the scheme is to enable greater exposure of wrongdoing in the public sector. The linchpin of the system is the protections that are provided to people coming forward making allegations. Those protections allow I'll use the term whistleblowers, so it's certainly losing gravitas these days. We're moving towards public interest disclosures as the language, but you'll see whistleblower, the word whistleblower creeps back in now and then. So people making disclosures that are assessed as protected disclosures in the current system are entitled to and have the protection of immunity from civil or criminal liability or disciplinary processes relating to their disclosure. There are penalties associated with breaching confidentiality obligations, so that the identity of a disclosure can be is kept secret. That's a requirement of the system. They're immune from liability for any defamation action that might flow from the nature of their disclosure, and they have protection from detrimental action arising from their disclosure of improper conduct. So consequently, they can sue for damages where there is detrimental action that's taken against them that has occurred because of their disclosure. They can seek an injunction to stop or remedy any detrimental action, and they can seek a transfer of employment. That right is not available for councils, but it is a statutory right for every other person in the public sector coming forward with an allegation of improper conduct. There are limits to this, so having made a disclosure does not indemnify the person against any disciplinary action or performance management if they're a party to the corrupt conduct. So you can't make a disclosure about your own corrupt conduct or improper conduct and then use that as a shield to prevent accountability for that conduct. And there are criminal penalties that apply to taking detrimental action and to breaches of confidentiality in the system. And here we see around these protections, here we see the necessary complications in the system. It's around these issues where we see some intricate statutory requirements that we'll talk more about this morning. The criteria for a protected disclosure complaint. So for a protected disclosure to attract the protections that I've just outlined, it must be made by a person. They could be an employee, a volunteer, a contractor, a secondee, anyone providing a service on behalf of a public body. It could be made by somebody completely outside of the public body. It could be made by a member of the public. So there's absolutely no limitation on who is entitled to enjoy the protections of the system if they have improper conduct to disclose. There's a requirement for the disclosure to be made verbally or in writing, or the person can make the disclosure in person. They can make it by phone, by leaving a voicemail message, or by any other form of electronic communication that does not require writing. If making a verbal disclosure, the disclosure must be made in private. This means that only the person making the disclosure, their lawyer representing the person, and one or more people to whom disclosures can be made must be present. Notes should be taken to the conversation. It can be recorded with the discloser's permission. Disclosures can only be made about public officers or public bodies, and we'll talk more about the definition of that in a minute. It must be about improper conduct or detrimental action, as defined. We'll talk a little bit more about that. So the current definition of improper conduct, what you'll see on the screen is a summary. It's accurate, but it's a summary of the current definition. So, the first 4 points relate to the definition of corrupt conduct, and they are included in the definition. So, improper conduct must involve the dishonest an allegation about conduct which constitutes the dishonest performance of public functions, or where there is a knowing or reckless breach of public trust, or misuse of information obtained in an official capacity, or a conspiracy to commit or attempt to commit the above conduct, must involve or substantial management of public resources, or raising a substantial risk to public health and safety that constitutes a criminal offence or reasonable grounds for dismissal. It's a complicated definition. That's the point of the slide. It's quite a complicated definition. It involves a combination of the definition of corrupt conduct and the definition of prescribed categories of specified conduct, which must constitute reasonable grounds for dismissal. So, in essence, it requires behaviour that either constitutes a criminal offence or it constitutes reasonable grounds for dismissal. And Sophie will explain how that's changing on the 1st of January. So just to put this in a bit more context, the protection of whistleblowers in Victoria, the legal protections for whistleblowers in Victoria commenced with the Whistleblower Protection Act 2001. This Act provided a prescribed list of public officers that were that were subject to the scheme, and this included municipal councillors and employees. It excluded certain judicial officers and parliamentary officers. They were carved out of the first iteration of this scheme. Complaints could be made to the relevant public body that employed those public officers or to the Ombudsman. Under that scheme, the public body itself assessed the allegation. If they determined that it didn't constitute improper conduct, the complainant had a right to refer it to the Victorian Ombudsman to make a determination. If the Ombudsman decided that it was improper conduct, then the Ombudsman was required to investigate the complaint. The improper conduct definition back then was much like the current definition, but there was a lower definition of corrupt conduct than now. So the corrupt conduct part of the definition didn't require it to be a criminal offence back then. So it was a lower threshold which existed for the first 10 years of statutory whistleblower protection in Victoria. Then along came, gone the wrong way. Along came the Protected Disclosure Act 2012. This coincided with the creation of IBAC and included the following key changes from the existing scheme. So there was an expanded definition of public officers. The definition of what constituted a public officer allowed the system to focus on the functions that the public officer was performing. So not just their role and their status, but the functions. So from 2000 and the commencement of that Act, the public officers could include contractors providing providing services to government that constituted public functions. So the scheme required IBAC to assess all disclosures, to set a consistent approach to the assessment of complaints and the investigation of serious and systemic corrupt conduct. So it created IBAC as the clearinghouse of all disclosures, to set a consistent approach, and to make sure that IBAC was placed to be able to investigate the serious and systemic corrupt conduct that triggers IBAC's powers. The improper conduct definition was lowered to include a more restricted definition of corrupt conduct. So that's slightly confusing. The definition of corrupt conduct from the commencement of that Act required it to be a criminal offence. So you can see this, the evolution of the system involves a lowering and then a raising of the definition of improper conduct. So IBAC's response to notifications or complaints. So IBAC's role involves the assessment of all disclosures. Then, under the IBAC Act, we are required to do one of three things. We're required to refer the complaint if the matter doesn't trigger our investigatory powers. So IBAC can undertake investigations in relation to suspected corrupt conduct, which is a subset of the broader improper conduct. So there's a higher threshold for IBAC to be entitled to investigate a complaint, and the complaint must constitute corrupt conduct. We, of course, investigate matters that trigger our investigatory threshold. However, we can also dismiss a complaint on the basis that it meets a set of prescribed criteria, which includes that it can be dismissed if the allegation is trivial. So we're experienced with handling some trivial matters which must be dismissed, and we'll come back to that when we talk about the changes. So just to give a bit of a snapshot of the current system, the lifespan of a protected disclosure. So we have a person there on the left making a disclosure to one of the receiving bodies, and then the receiving body, which includes most of your organisations, is required to notify IBAC of the complaint. We've got the VI there, that's the Victorian Inspectorate. They're the body that receives complaints about IBAC. It's there for accuracy. But the vast majority of all complaints are required to be referred to IBAC for assessment, and then IBAC decides whether to dismiss, refer or investigate that complaint. Under the current system, IBAC can only refer to the Victorian Ombudsman, the Victorian Inspectorate, the Judicial Commission or Victoria Police for investigation. So we're limited to those four bodies specified on the right there for the purpose of an investigation. So that's changing. Just a bit of a note. The system does support the taking of urgent action. So we have these protections and confidentiality requirements that prevent communication about the identity of the disclosure or the content of the disclosure, to make sure that IBAC and any other investigation body is able to investigate that matter without raising a significant risk of destruction of evidence. So it's an important, one key aspect of the system. However, there is a release valve right at the start. If you're responsible for receiving a protected disclosure, it's just a note to say that you can refer that to police or another body if it's necessary to take immediate preventative action. And examples would be where there's an immediate threat to health and safety, or there's a need to disclose allegations of serious criminal conduct. And there'll be examples of those which are obvious, where there's a matter that requires an immediate intervention to prevent further harm or public safety issues from occurring. Welfare management is not a statutory requirement of the system, but the Protected Disclosure Act does require that an organisation have procedures in place to protect people from detrimental action. So an organisation has legislative and administrative obligations for the welfare of a person making a protected disclosure. This is a key feature of the research that's been undertaken in Australia over the last 10 years or so, where ensuring that an organisation has the right culture and conditions to support the making of disclosures about improper conduct is a key factor in ensuring that allegations come forward. It's kind of common sense, right? If you've got an organisation that is clearly set up to respond to the needs of its employees, including in the circumstances where they are making an important allegation of improper conduct. If you've got the right culture settings and the right welfare arrangements around the processes of making complaints, you're more likely to be contributing to an organisation that complies with the Act, but that will actually support the spirit and the operation of the system. It's an important obligation, though it's not a legal obligation. It's an important feature of the system. Managing confidentiality. So, of course, we've been talking about confidentiality. So organisations that can receive protected disclosures must have processes and systems that support confidentiality. So you must be able to receive disclosures confidentially, secure information management systems for storing information about protected disclosures. So disclosure can't really be made as an informal note in the diary. It just doesn't provide continuity in the event of staff changes. So information needs to be stored somewhere secure that can only be accessed by authorised people, such as a secure electronic database with password access. An Excel spreadsheet is unlikely to be secure enough for confidentiality purposes. Bodies must have a secure means of notifying IBAC of accessible disclosures. This means by mail or email. So just a little bit more in terms of numbers of matters showing IBAC's work. So last financial year, we assessed 742 matters for protected disclosure status. Out of those, we referred 544 to the bodies listed there, and we undertook 24 investigations of those matters, and we dismissed 174. Just to give you a bit of a profile of IBAC's work. Now we turn to the changes that are starting on the 1st of January. So we're providing details of these four groups of changes. So the legislation will include a broader definition of improper conduct. It provides for increased protection for disclosures, clarified confidentiality requirements, and some new pathways for disclosures. This is what we'll explain. So the Act name is changing on the 1st of January from the Protected Disclosure Act to the Public Interest Disclosures Act, and all reference to protected disclosures will be replaced by the term public interest disclosures. And once a disclosure has been determined to be a public interest complaint, that term will apply. So it's all about public interest disclosures and complaints from the 1st of January. So the changes in the name and the key descriptor of the activity being protected by the legislation reflects the important role of disclosures in upholding the highest standards of public sector conduct. It also aligns Victoria with the other states. So what we'll do now is hand over to Sophie, who's going to talk about the new definition of improper conduct. Switch that.
Okay, as Phil said, there's been changes to the definition of improper conduct, which I'll take you through. So, as Phil flagged, so for something to be a public interest disclosure, you need to be giving information either about improper conduct or detrimental action. The definition of detrimental action hasn't changed, so I'm just going to leave that aside totally, and we'll just look at improper conduct for now. So Phil gave you an overview earlier which pointed out how complicated the current improper conduct definition is. It's got confusing threshold requirements which will apply to certain types of conduct but not others. What the government who's passed the legislation have tried to do is just streamline it so it's a little bit more simplified. So essentially what's listed up on the screen here, corrupt conduct, criminal offence and all the following, if behaviour that fits within any of those categories is seen, that will constitute improper conduct. There's no question of threshold that arises. We've also just put there a couple of things in red which are key things to note. I'll start from the bottom, counterintuitively. We've put in red conduct of any person. That's not a change, it's just always good to remember that for the types of conduct that would fall within improper conduct, you're not always just looking at public officers or public bodies. You could be looking at third parties who are trying to influence the actions of public officers or public bodies. That's not a change, it's just good to remember. One of the other quite minor changes we've put in red is that where previously the category of conduct was substantial risk to public health or safety, they've changed it to substantial risk to the health or safety of one or more persons. Presumably they haven't given an explanation for that change, but I think our interpretation would be that it's lowered, so you're not looking for such a significant impact on people. It can be a smaller group of people impacted as long as it's still a substantial risk. The key change to note is the top red one, which is that they've included a new type of conduct, serious professional misconduct, which, if found, can constitute improper conduct. So, as this slide says, it's not actually defined in the legislation. So, because it's not defined in the legislation, in order to give some guidance, we have tried to think about what it's likely to mean based on how similar terms have been used in other pieces of Victorian legislation, based on how the context of the scheme and just the basic meanings of the word. So, I think probably a good working understanding, just based on the meaning of the words, is that it's going to relate to actions where there's a failure to fulfil certain professional functions or to behave in accordance with certain professional requirements of a particular office or a particular workplace. The second paragraph is really our understanding, our sort of summary version of what that might mean, but exactly what the requirements might be of any particular office or will depend on the particular office held. So it's going to be a really context-based assessment as to whether someone's fulfilling their obligations of their office and their workplace. So because it's context-based, we've put up a few factors to consider. So on the left-hand column there, these might be factors that could be useful in pointing out what the particular expectations or skill levels are of a particular office when you're assessing whether or not someone will have fallen short of those standards. So it might be things like comparison to peers who hold similar office, whether or not they're acting in accordance with similar standards of behaviour, whether they've got similar levels of skills. Position descriptions will always give you a hint about exactly what the expectations are of a certain office. And also broader pieces of like codes of conduct. For example, the Victorian public sector has its own code of conduct, or potentially more specific ones. Nurses have their own code of conduct. Breaches with those sorts of more specific codes of conduct would be a good place to look for serious professional misconduct. We'll have questions at the end if that's all right. Okay, and then because it's serious professional misconduct, it obviously need to reach a certain standard. So improper conduct doesn't include anything trivial, and to reach serious professional misconduct, it will often have to show certain factors which we've put in the column on the right. That might be where the conduct is deliberate, where it's persistent, where it creates quite a high-risk environment, or where the impact on the public sector because of the particular faith in the seniority of the office would be quite drastic. So all of those will inform whether or not it constitutes serious professional misconduct. And something to bear in mind is, like, as I said, this is just our working understanding. So as things come into effect from the 1st of January, it may be we get more of a read from the complaints that get filtered through what is likely to fall within this head. So hopefully it's going to be a learning process for us, or we'll be able to fix on a clearer definition of what this will mean in due course. Okay. The next step I wanted to go to is changes have been made to the protections that are given to disclosures, which Phil ran through earlier. So he noted that there's a prohibition which comes with criminal penalties attached for someone who takes detrimental action against someone who makes a disclosure. It used to be that that prohibition was only triggered where the disclosure was the substantial reason for the detrimental action to be taken. That word substantial has been taken out. So now if detrimental action is taken and against a disclosure, and the disclosure was any part of the reason for the detrimental action, that'll be prohibited. So it just broadens the application of the prohibition against detrimental action. One of the other changes is that, as Phil flagged earlier, there's an existing right to sue for damages if detrimental action is taken against you. The government noted that not many people were actually taking advantage of that right, and their theory was that it was because people were worried about an adverse costs order being made against them in the event they weren't successful. So what they've done here is given a limited liability for costs if a disclosure wants to sue for damages, with the necessary exceptions. So if the claim is vexatious, or if the conduct during the course of litigation is unreasonable, the limited liability of costs won't apply. Okay. There's also been some modifications to the confidentiality obligations. As it stands, if a receiving body determines something is a protected disclosure, or soon to be a public interest disclosure, and decides to refer that matter to IBAC, that is confidential. So you would have presumably given that assessment letter to the disclosure themselves to say, yes, we think it's a public interest disclosure, we're sending it through to IBAC, you can't tell anybody about that. that confidentiality obligation has been repealed entirely. So that decision to pass it through to IBAC is now no longer confidential. The other key change is that as bodies who receive disclosures, you're obviously subject to certain confidentiality obligations, but modifications have been made so that if necessary, disclosures can be made to crucial welfare or support services. So if the discloser wants to make, for example, a disclosure to WorkSafe about their disclosure, and they want the support of their manager to whom they've also made the disclosure, that manager can talk to WorkSafe to support the employee's claim at WorkSafe. I'll go to the next slide because we've got it in a bit more detail. Okay, so sections 52 and 53 are the key confidentiality obligations in the Public Interest Disclosure Act. And as I said, they essentially require confidentiality of everyone who receives protected disclosures, except in certain circumstances, and those exceptions have been broadened. So where you can make further disclosures where it's necessary to assist seeking support from medical practitioners, confidentiality, employee assistance programs, trade unions, for a workers' compensation claim to work cover, and for an application to the Fair Work Commission. And similar broadening of the exceptions to the confidentiality obligations have been made to anyone who's issued a confidentiality notice. So often disclosures will fall under that second category. If they have highly sensitive information, an investigating body like IBAC might issue a confidentiality notice to them saying you can't share this information with anybody else, or about the investigation itself, etc. So this second category says that if you're the subject of confidentiality notice, that information is restricted, except now in the additional circumstances, you should be able to tell your spouse or domestic partner, your employer, your manager, and those same support bodies that are listed in that top section. I think I'm handing back to Phil here.
For those of you that are worried about screen time on your devices, using Slido.com is not going to, it's only going to add a little bit to your daily screen intake. So just putting in a plug for use of the Slido.com system, just for any question. I think there was a question over here that popped up when Sophie was talking. So you go to Slido.com and then you enter PID as the, what's it called, the event code. Yep. So please do access that. We've probably got about another 20 minutes of talking before we'll go to questions, just to get through the remaining parts of the changes and some case examples. So, what are the new pathways for disclosures? The first one to mention is the introduction of the no wrong door principle. So currently, a disclosure must be made to a body that is entitled to receive that particular disclosure. So for instance, a disclosure about a counsellor currently must be made to either IBAC or to the Victorian Ombudsman. Under that scheme, if you make a disclosure about a counsellor to any other body, that disclosure is not currently protected by the system. So that's an anomaly in the system that the changes will attend to. So it's referred to as misdirected disclosures. So where a discloser believes that they're making the disclosure to the correct body, but it's the incorrect body, if that incorrect body is otherwise entitled to receive protected disclosure complaints, then it can be accepted as a protected disclosure complaint. It will retain the protections of the scheme. I'll come back to a case example about that. But The requirement is that the person must believe that they're going to the correct body, and that the body that receives it is otherwise entitled to receive protected disclosures generally. Having received the disclosure, the body then has a choice as to whether they refer it to IBAC or whether they advise the discloser that they must make it to the appropriate body. So there's some choice built into the system there. I'll come back to some case example of that. So we have a new receiving body. This is really just to clear up a gap in the system, in that the new parliamentary body that is at the peak of the integrity system, it's the Integrity and Oversight Committee of Parliament. That body can now receive disclosures relating to the conduct of the Victorian Inspectorate. The Victorian Inspectorate has oversight functions of the integrity system, and at the moment there's no place to take a protected disclosure complaint about the Victorian Inspectorate. So that's the only change in terms of the new bodies that can receive. New referral options. Here's where we see some of the more significant changes that will affect the operation of the system, especially from IBAC's perspective. We have some new investigating bodies. We have the Chief Municipal Inspector. We have the Racing Integrity Commissioner. And we have the Information Commissioner as new bodies that can investigate protected disclosure, public interest complaints. I'm reverting to the new language. So those bodies will be able to investigate public interest complaints, where those complaints relate to the functions of those bodies, with some restrictions. So the Racing Integrity Commissioner and the Information Commissioner will be able to investigate public interest complaints, but not if they are allegations of corrupt conduct. So again, it's emphasising that IBAC's jurisdiction is the investigation of corrupt conduct, and so there's some changes in there that will emphasise IBAC's role in that regard, but provide the Chief Municipal Inspector with the ability to investigate relevant complaints, including corrupt conduct complaints for concerning local government. So they're the new referral, the new investigating bodies. Secondly, there's some new flexibility that's been built into the scheme to enable a public body that cannot investigate a public interest complaint, to enable that public body to deal with a matter. Now, what this means is that what the system will require is that IBAC receives a complaint. IBAC now will have the additional discretion to refer that matter to another body for action, but only if the complainant and the body receiving that referral for action agrees. So there's some additional communication and consultation requirements on IBAC before it accesses that additional flexibility that's built into the scheme. I'll come back to a case example of that to explain that further. In addition to that flexibility, IBAC will also be able to delay its assessment of a complaint for up to 90 days. And this is a facility that will enable, where there is appropriate action being taken in relation to the subject matter of a complaint, for that action to be completed before IBAC makes a determination as to any further investigation of that matter. So it's a way to avoid IBAC being required to interfere with sensible, reasonable, appropriate action to follow up on a complaint that might be taken by any body involved in the conduct. So there are two important avenues for additional flexibility in the system. And lastly, external disclosures will be permitted in certain circumstances. So at the moment, the system is quite restrictive in that a public interest disclosure is made. That disclosure enters the system that we've been explaining, and then there can't be any external communications about this complaint until the integrity agencies have done their job completely on the matter. So as part of the consultation process that the previous parliamentary committee, the IBAC committee, undertook a few years ago, it really identified this gap, that in the unlikely event that the integrity system simply fails to respond to a complaint, the complainant has nowhere to go. So this additional mechanism will enable a discloser to go public, if you like, about a complaint where there is a failure of the system to respond. I'm not aware of any case where that's actually occurred, but it's plugging a gap in the system. And there'll be some strict requirements about that. So a discloser can only make an external disclosure to a journalist, for instance, where there's been a failure of an investigating body to investigate a matter for a period of 12 months, and where there's been a communication seeking an update about the actions being taken to investigate the matter, and there's been a further failure to reply to that request for 30 days. There's a couple of safeguards in there to make sure that the system, the integrity of the system is maintained. And disclosures to journalists will only be permitted where there's an utter breakdown in the actual operation of the integrity system. Okay, so we have some changes to the mud map of the lifespan of a public interest disclosure. Remember the diagram we had up earlier. We have a person making a disclosure to a receiving body. That receiving body is required to notify IBAC invariably, or in the rare case of a complaint about IBAC, to notify the Victorian Inspectorate. And in the rare case of a complaint about the Victorian Inspectorate, to refer it to the Integrity and Oversight Committee. And IBAC can now refer, as I was saying, to some additional investigating bodies, and we have some additional flexibility in the scheme to refer to bodies outside of the scheme for action where the complainant and the body that's taking that action agrees with that referral for action. Okay. So now we'll just discuss a short number of case examples. Firstly, to deal with the new definition of improper conduct. So these are examples of allegations, and this is very summary, just to give the flavour for the type of matter that we're envisaging would be likely to fall within the new definition that doesn't fall within the current definition. So complaint that a psychologist employed in a council clinic has disclosed confidential client details without consent. So in that matter, what's being engaged is the psychologist's code of conduct, if not the confidentiality obligations within the Health Records Act. And those are the types of, depending on the seriousness of the unauthorised disclosure, that's an example of something which would fall within the new definition as serious professional misconduct. Remembering Sophie's discussion about the seriousness threshold. It has to be serious. And remembering that there's that it won't meet the definition if it's trivial. So we've got, you can see in practice when we come down to examples, and we'll be looking forward to providing some more guidance and information in the new year once the new system gets rolling. And the second example is a complaint that a town planner has an undeclared conflict of interest in a planning application process. Now, within the current definition, if that conduct doesn't constitute reasonable grounds for dismissal, or if it doesn't constitute a criminal offence, it's not caught within the current definition. Within the new definition, that may constitute serious professional misconduct, depending on some of the factors that Sophie outlined earlier. So, an example of a repeated failure to comply with the procedures around declarations of conflicts of interest is probably going to constitute a breach of the public sector code of conduct, may constitute a breach of in this case, a council's employment requirements and internal processes. If it's serious, again, it may fall within the new definition. And thirdly, a complaint that a depot manager repeatedly refuses to obtain 3 quotes in breach of council procurement rules. Again, we can see this may not constitute reasonable grounds for dismissal. It may not. It's definitely not going to be a criminal offence in most circumstances, and it certainly may fall within the definition of the new scheme. So you can see here that with these examples, this lowering of the threshold, coupled with the increased flexibility of IBAC in how it can deal with the matter, they are sort of balancing mechanisms in the scheme. In short, more complaints coming through the gate, but more flexibility in how those complaints are resolved appropriately. By the way, I haven't yet put in a plug for the information packs that are sitting on your chairs, but there's 2 information sheets and a fact sheet which provide more detail than what I'm going through here. So just to be aware, they're also on our website. And if you have any difficulty finding it on the website, please just let us know. But those information packs constitute the most detail that's available about the operation of the new scheme. These slides will all be available made available to everybody here. Okay, so the other couple of case examples, we're nearly done. Just do a quick time check. So we'll probably go for another 5 minutes before question time. A misdirected disclosure. So, a complaint that a councillor is receiving bribes made to the Municipal Protected Disclosure Coordinator. So, in the current scheme, as I said, as an example of the restrictive nature of the scheme, and there's plenty of other examples of this, but just in this particular example, complaints about councillors can only be made to IBAC or the Victorian Ombudsman. Now, complaints about council employees, about the council itself, can be made to the council, but complaints about councillors must be made to IBAC or the Victorian Ombudsman. Under the misdirected disclosure scheme, this is an example, and it's possibly a likely example, where a complaint is made to the Protected Disclosure Coordinator of the council about a councillor, and technically that Protected Disclosure Coordinator cannot receive that complaint under the current scheme. However, under the misdirected disclosure provisions, the Protected Disclosure Coordinator will have a choice as to whether they receive that disclosure and refer it to IBAC, or whether they advise the complainant to go to IBAC direct. So that's an example of the misdirected disclosure scheme in practice. I'm sure you can think of others. Okay, an example of a matter that might be referred to for action to another body by consent. I was talking about that other new aspect of the flexibility in the scheme. So in an example of a complaint that a public officer has produced an investigation report that contains serious falsehoods and omissions, that is a matter that may or may not meet the test of improper conduct. There's likely to be some detailed deliberation on whether the omission or the falsehood constitutes serious professional misconduct of the investigator. What the scheme will have from the 1st of January is the ability for IBAC to engage with that complainant to discuss options for resolving that matter. And clearly, in that example, there's a clear action that the complainant is likely to be seeking. Amendment of the report as an action that would resolve the complaint. So the scheme will support the ability of IBAC to approach the complainant, look at that as a possible outcome of their complaint, and to then go back to the body concerned and discuss that option. Obviously, there are a number of concerns that have to be built into what IBAC does around protecting confidentiality, around making sure that we don't do anything that might prejudice full investigation of that matter. So there's a range of issues that would need to be considered. It's an example of the kind of matter where we would be able to refer it for action without necessarily requiring the allegation to be investigated. So again, it's emphasising that from the 1st of January, there will be increased opportunities and increased responsibility of IBAC to communicate with people making notifications to IBAC, but also to the complainants, to the people coming forward with their protected disclosures. So now we'll go to Slido. Can we bring up the slide? The slide. What's it called? And what I'll do is I'll switch this off. And Sophie, you switch your microphone back on. Okay, so yes, we can get a copy of the slides. I thought that might have been a question. So that's a very affirmative, quick answer to that question. Okay, the next question. What are the legislative obligations for bodies that can't receive public interest disclosures? So bodies that aren't entitled to receive public interest disclosures are excused from the requirement to have procedures for the receipt of those disclosures. And under the protected disclosure system, those bodies don't have any express statutory obligations within the scheme. However, the spirit and the purpose of the entire scheme is to support those coming forward with public interest complaints. And so I don't think it's sufficient for any public body to simply step back from any responsibility for integrity and contributing to Victoria's integrity system. Does anybody want to add to that answer from my colleagues over there? And I should say, feel free to put your hand up and ask questions from the floor. Can I just hand you the microphone so that the webinar people hear the question?
Thanks. So just to clarify then, the misdirected disclosure changes don't then apply to bodies that don't strictly receive protected disclosures.
That's correct.
But in the spirit of the regime, you're recommending that they do apply the similar kind of process?
Well, in that example, a body that's receiving a misdirected disclosure that isn't entitled to receive that disclosure, there's no change. In the current scheme, they're not entitled to receive, and the disclosure is technically not protected in that disclosure. So they need to be told to go direct to IBAC, and the complete answer is that they should be warned about making their disclosure to a body that can receive it. So the misdirected disclosure provisions only apply to bodies that can generally receive disclosures. Yep. Okay, next question. Under what circumstances can the issue of bullying be considered as serious professional misconduct? How would the allegation be assessed? Excellent question. So this question actually triggers a quick comment about one of the fundamental aspects of the system, which is that often people who have a complaint to make that is serious, that concerns improper conduct, sometimes the trigger for that complaint coming forward is management action that they're not happy with, or other activity within the organisation that makes them unhappy and just trips them over the line into being prepared to raise a serious allegation. So it's a frequent. There's a frequent concomitant relationship between a protected disclosure complaint and a workplace issue. And it's something that AJ Brown has discussed in his research into the most effective organisational culture to support whistleblowing, and it is something which is likely to increase with the lowered threshold that's coming in on the 1st of January. So in terms of looking at the criteria that might be triggered in a bullying allegation, the new definition certainly would support some types of bullying allegations being considered improper conduct, as it currently does, and the criteria that Sophie discussed earlier would really be the current assessment tool that we would bring to bear on an allegation. But Sophie, do you want to add to that in terms of the circumstances that might be triggered out of a bullying allegation?
Look, my understanding is that things that, because all we have is this vague expression, serious professional misconduct, we're sort of trying to figure out as we go, but things that might constitute bullying, which maybe raises issues under like the Occupational Health and Safety Act, things like that, might fall within the definition of serious professional misconduct, because those sorts of acts are meant to regulate workplace behaviour. Where there is a serious flouting of those sorts of behaviour, it potentially could cross the line into serious professional misconduct. It's obviously still a complicated process, because while that seems like it may be falling within the intention of the ambit of the scheme, it's not necessarily within the wheelhouse of any of the particular our investigating body's jurisdictions. So there's a slight mismatch between the scope of what protected disclosures are encouraged by the definition of improper conduct and what the specific investigating bodies can look into. But that said, there's still value in things falling within the system because the protections are triggered, regardless of what then investigation or not is done.
And the other issue that's triggered there is, of course, this added flexibility for an allegation to be referred back to an agency for action, and that especially would apply where there is contemporaneous workplace relations proceedings that are on foot. There will be the ability, if the complainant consents, to have the action taken on their complaint dealt with through that other process. Currently, there are multiple swim lanes built into the system. There are a range of dual reporting obligations. Say in the WorkSafe context, there's an obligation to notify WorkSafe of safety issues. Where that safety issue also constitutes improper conduct, there's the ability to notify and a requirement to notify IBAC if it constitutes corrupt conduct or if you receive a notification about a safety issue from a complainant. This is part of the current normal operation of the scheme. Multiple swim lanes, and as I keep saying, there'll be an increased responsibility of IBAC to communicate with the parties. Next question, does the new legislation operate retrospectively? So inbuilt into the current scheme is the ability for a complaint to be made about conduct that occurred before the commencement of the scheme, and that provision hasn't changed. However, so from the 1st of January, the new definitions will apply to the disclosure. So the disclosure can be about conduct that has occurred in the past. It's not made express that the provisions are retrospective, and in the absence of that, we need to pay careful attention to the requirements of the existing scheme, which includes, as I say, this ability for a complaint to relate to prior conduct. Next question. What sort of role holder and level of seniority do you recommend to be a PID coordinator? So the appointment of a PID coordinator is not an express requirement of the system. Since 2001, the appointment of a protected disclosure coordinator has been a convenient way for an organisation to focus its activity and to make sure that there's somebody in the organisation that's responsible for receiving the complaints and for attending to the other responsibilities on organisations in the scheme. Because we have 3,500 organisations that fall within our jurisdiction, we are a bit reluctant to make prescriptive requirements around issues such as that. It really requires the organisation itself to assess its size, the capacity and capability of the organisation generally, and of particular divisions and parts of the organisation to be able to handle the legal responsibilities within the PID scheme. But of course, some of the features of a person receiving complaints would include, some experience in managing legal transactions, the ability to assess information according to legal criteria, good communication skills, and the ability to operate with integrity and confidentiality at all times. So there's obviously a list of sort of behavioural characteristics that I've just started rattling off, but I'm sure you can add many requirements to that list, which are, that's more the issue rather than the seniority. Of course, being close to the senior leadership is important because of the nature of the obligation goes to the heart of the integrity of the organisation itself, and so having the ability to influence senior management with the appropriate confidentiality requirements in place is critical. Comment? Please?
Just for the risks. I've got a specific example not relating to Australia. It's my time overseas. And I agree with the comments you made around the features and the characteristics of the person. But the problem I see is that being close to senior management is a problem, because senior management is quite often, in my experience at 20 odd years, the problem. So that's where I see that there could be conflicts of interest with the public interest disclosure and their relationship to management, because these are quite often their peers and who the PID might relate to. So in many instances, it would be difficult for them to separate that role in order to conduct that, which is why I put the other point in there, is why don't people just go straight to IBAC or the VI? Yeah. Because I think they're taking a risk going through the PID.
Yeah. So those are very important and relevant comments, and they go to the heart of the challenge that is before anybody that's involved in receiving a disclosure of improper conduct. There's no neat answer. One of the things I was thinking when you were talking was that an inappropriate handling of an important disclosure by a CEO would, in and of itself, under the new definition, constitute improper conduct, given the lowering of the threshold.
The example that I know of when I lived in the UK was the disclosure was made, and then this person was bullied out of the role.
Yeah.
So it's interesting around that point around the bullying as well.
Yeah, the participant was just for the webinar. The participant was just giving an example of a person who makes a disclosure, who's perhaps even received the disclosure, who's then bullied out of the organisation. Now, that's a great example of the conduct that the scheme is designed to prevent and provide accountability around. As I say, the new inclusion of serious professional misconduct. It's a flexible part of the definition. We'll be exploring its boundaries. We've got a pretty clear view about what those boundaries are, but they may certainly include a failure of an organisation to respond to an internal communication about serious conduct. Okay. Okay, where are we up to? What is the difference between serious professional misconduct and the common law Fair Work definition of serious misconduct and or misconduct under the PA, Public Administration Act? So that's a sort of an easy conversational topic, but it's an important question. I'm really hesitate to sort of give advice off the cuff. The interplay between the acts, and certainly there's no intention in the scheme for one definition to refer to the other. They are distinct schemes, but I would encourage whoever's asked that question to get in touch and we can sort of explore the implications of that a bit further. But do you want to add to that, Sophie?
Essentially not really, but I guess, as Phil said, there's clearly no direct link planned between at least the formal statutory definitions, just because they've given us nothing for our Act. In terms of how the common law one might feed in, I suspect a lot of the factors or even the case law around the seriousness will be relevant as we do assessments as they go. But just because this particular term, serious professional misconduct, hasn't been used in Victorian legislation before that we can find, we don't think there's perfect parallel that we can just import across to our Act. But very much the thinking around these sorts of definitional terms is going to impact how we interpret it as it goes, yeah.
Okay, just rolling through the questions. Do we have any sort of comments from the floor or questions from the floor before we go on? Okay, so next question is about statistics. We received 742 disclosures in 2017-18, but only investigated 24. So I'll just stop there. Why so many referred, and what constitutes the 24 to IBAC? So those 24 were matters which triggered our investigation powers threshold and or matters that responded to our statutory obligation to prioritise the investigation of serious and or systemic corrupt conduct. So that's where our powers and resources are required to be directed by statute, and that's the explanation for the number of matters that we've investigated and the number of matters that we've referred to other bodies. We are set up to investigate serious and systemic corrupt conduct while we're engaged also in the prevention of corrupt conduct and police misconduct generally, but our investigation powers are quite constrained to corrupt conduct, subject to an obligation to prioritise serious and systemic corrupt conduct. So that's the short explanation. There's a slightly longer explanation which also looks at, as you saw, around 60% of the complaints that we received concern police misconduct. The vast majority of those complaints we refer to back to Victoria Police to investigate. And again, it falls within the rubric of our responsibility is to investigate serious and systemic corrupt conduct. But also, we have to refer to a body that has the appropriate powers to investigate a matter. And in the police misconduct space, we don't have the same powers as police to collect forensic evidence, to undertake certain search and seizure activity in real time without warrants. So there's some constraints around our powers that contribute to the discussion about why we refer so many of our complaints back to Victoria Police. Question over here again. Can I hand you the microphone again?
Sorry, this appears like a really dumb question, but just your point now about 60% of the complaints relate to the Vic poll, but then you refer them back to Vic poll to investigate those same complaints. So what's the rationale with that? I understand you were saying about the lack of powers, but surely there should be an alternative. You know, I'm just worried about the risk of, you know, it's like the fox and the chicken coop, you know, that sort of scenario.
Yeah, and look, this matter was the subject of a parliamentary committee inquiry that reported in August of last year, and government has not yet responded to that report, and it touched on the very themes that you've articulated there. And so in the context of government not responding waiting to respond to the recommendations of that report that went to IBAC's role, it's a little bit difficult for us to sort of step into that void and make further comments on it. That issue is about the most effective and appropriate arrangements for handling police misconduct complaints is something that's very much before government at the moment. And, you know, we'd be anticipating a response from government hopefully soon to pick up on that important observation. Okay. Right. Are not-for-profits subject to the Act, especially where they receive government funding? The answer is categorically yes, but subject to, as I was explaining earlier, the test for performing the test for public body under the Protected Disclosure Act refers back to the definition in the IBAC Act. Before I lose you all in an intricate web of legal definitions, the basic answer is that for a body that is performing public functions on behalf of the state of Victoria, those bodies or the public officers engaged in those activities are subject to IBAC's jurisdiction and subject to the scheme that we've been talking about all morning. Does that answer the question? Yes. So not-for-profits bodies are subject to the Act, but they're subject to only if their activities fall within the definition of a public body. That is, they are performing functions on behalf of the state of Victoria. And that will be determined by such things as the content of legislative obligations that they might be delivering on behalf of the state of Victoria, or it could be determined by the extent of funding that they receive from government. If they receive 80% of their funding from government and they provide services that government is required to deliver, then they are going to meet the definition of a public body, as an example. Trivial interpretation, please. Oh, sorry, I'm leaping ahead. As the new legislation mirrors other states, what are the known impacts, outcomes in these other states? Have complaints gone up? So one thing I didn't say is that IBAC's actually unique nationally. We perform functions that are combined in IBAC, which in other states are distributed to other organisations. So we are kind of unique. There's no sort of neat answer to that question, and each state has quite distinct definitions of improper conduct which appear similar but contain slight technical variations that may mean unfortunately there's no simple answer to that question. But look, we're anticipating some kind of an increase in the number of complaints and notifications that we receive, and we're loath to sort of set defined expectations around that. But look, as I'm saying, we've also got more flexible options about how matters can be handled as well. Okay, please, Sue. Sue Camaralakos.
Thank you. I think it's important, if we do get an increase and you do have a matter that you would like us to expedite, you just need to call. So it will help us identify which one that might be, and we can actually move a little bit more quickly on that one. So we are wanting to work with you to ensure that we are as efficient as we possibly can. Thank you.
Thanks, Sue. Yeah, Sue's team and the assessment and review function of IBAC is really, it's really the gateway of all information coming into IBAC. So Sue and her team perform an absolutely critical function in the operation of the scheme, and as Sue says, we're very keen to interact on a case-by-case basis whenever necessary. Okay. Trivial interpretation, please. Will this be developed? Will there be a library of examples of trivial matters developed in the future? Now, Jasmine, I know this is something that you've had some interest in the past. Do you want to jump in, or would you prefer me to tee off on the answer? Yeah. Okay. So I was going to say we have experience with assessing matters that are trivial, as I say, because we can decide to not investigate a matter that is trivial, which otherwise would be defined as improper conduct. So the inclusion of the the exclusion of trivial matters from the definition of improper conduct enables the scheme to not respond where there are trivial allegations. For instance, behaviour that might constitute criminal conduct, but which is nevertheless minor, such as an isolated theft from the stationery cupboard, such as an isolated example of timesheet manipulation. So these are matters which would constitute technically a criminal offence, which could trigger the threshold, but which are trivial, which don't relate to the spirit of the scheme and the requirements of the scheme to focus on the prevention of corrupt conduct. Got a question over here. I'll just get you to talk to the microphone for the webinar.
Thank you. I was just thinking trivial could be a very subjective kind of test depending on where you come from, obviously. So hence the library.
So again, I think what we will be doing as we see examples, the aim is to collect a bit of, I guess, a series of case studies to help educate and spread the word, to help support you, I guess, as this new legislation comes. I guess we experience the new legislation. And I think even having spoken to Jed, we will be watching and observing what comes through, and we may hold another forum in the future to sort of share what our experience has been as the central body. Yep.
Okay. Next question. Why don't you read it?
With the lower thresholds and increased protections for disclosures, what resourcing plans are in place to support the increase in PIDs?
Once again, this one is, we don't know what we don't know, but what we do know is we have a full team, a full complement of team with very experienced team members that are very well versed in assessments and being responsive. We are, I guess, continuously reviewing our processes to see how we can create efficiencies. And we'll be on, I guess, a bit of a watch and see approach. And we are developing plans to be as flexible as we possibly can and have that extra pathway of if there is a matter that you do wish us to consider for expediting, we will deal with those on a case-by-case basis and happy to receive a call.
Okay, so the next, thank you, Sue. So the next question is, principal officers must report if they have reasonable grounds to suspect corruption has occurred. Is actual knowledge required, or can it be imputed to the principal officer? So that's referring to the current and unchanging obligation to report corrupt conduct. So the mandatory notification requirement in section 57, subsection 1 of the IVAC Act. And the simple answer is that no, actual knowledge is not necessarily required. The circumstances that give rise to the forming of a belief is what is relevant. Yeah, it's a bit hard to take that much further, but it's a low threshold that triggers a requirement to report corrupt conduct to IVAC by the relevant principal officer of a public body. And as you can see from the intended operation of the scheme, it's important that threshold be kept reasonably low so that IVAC is in a position to take action on suspected corruption. Next question. Does the misdirected disclosure regime cover entities that have obligations preventing detrimental action but cannot receive any protected disclosures? Simple answer is no. Misdirected disclosures only apply to bodies that can otherwise receive protected disclosures. Do you want to read them?
I think this one is the comment you were making earlier, but I'll just repeat it. Surely it's better for disclosers to disclose directly to IBAC or the VI rather than through the Protected Disclosure Coordinator. Less risk of conflict of interest issues. Which I think is a good comment, and I'll move on to the next question. Does a discloser have any input into who, for example, IBAC or the disclosures organisation, investigates their disclosure?
The answer is yes. So IBAC will assess all information that it receives. So do you want to say something further about that?
Maybe Jasmine can also add to this. I think it is the quality of information, but I will hand over to Jasmine.
So we'd certainly take into consideration any concerns that the discloser might have in relation to their disclosure being referred to another one of the investigative bodies. It might mean that if there were really grave concerns about their matter being referred to an agency and it doesn't meet IBAC's threshold, that might then mean that we dismiss the disclosure. But we'd certainly take into consideration their concerns as well as the information that we've got in formulating a recommendation about what to do with the disclosure.
Okay, now I might just sort of start trotting through these. We're sort of probably getting ready to wrap up. I'll just put in a plug for the evaluation sheets that are on each of your chairs. If you could please complete those evaluation sheets before you go and leave them on your chair. But the next question is about whether we'll be holding another seminar. Our obligation under the Protected Disclosure Act, soon to be the Public Interest Disclosure Act, is to provide guidance to the public sector. We do that through a range of mechanisms. Obviously, our website is a primary communication tool that we use, but hosting seminars such as this is also an important way that we do that. And we've got various plans for further events in the new year as the new system commences operation. Does the establishment of the Integrity Oversight Committee of Parliament undermine the work, including autonomy of IBAC? Great question, and the answer is no, it doesn't, because it has specific restrictions in its functions that don't allow that committee to deal with any decision of IBAC's. So they cannot exercise their oversight functions in relation to a matter that IBAC is in the process of making a decision about, or indeed that IBAC has made a decision about. So there's a complete carve-out that maintains the independence of IBAC. Okay. It's 11 now, is it? Okay. Well, look, what we'll do is take the webinar recording. I'm not sure. Are we recording that? Are we able to? We might be able to consider distributing that. We'll consider that, and we might just leave the other questions on notice, and we'll provide answers to those the last few questions that is coming through. By email, we've done that before, haven't we, Jed? We've provided answers to questions we haven't reached.
There are FAQs in the past there as well. Somebody else might be there.
Yep. So thank you very much for coming. Congratulations, you got through the longest slide deck that we've ever presented, I think at 47 slides or something. And you made it through the cordon of the tram works and everything. And hopefully you've just got a little bit more information about the operation of the scheme and what's coming next year. Stay in touch. Thank you.